It's a pleasure to be here. My name is Rick Banks. I'm a member of the law school faculty here and the faculty director of the Stanford Center for Racial Justice. This is a joint production of the Center for Racial Justice and the Stanford Constitutional Law Center. We're delighted to have you all here. Let me just start by thanking Morgan and Wang, who organized this. Morgan for the Constitutional Law Center, Wang for the Justice Center. Literally could not have happened without them. So thank you both. And let me also thank our guest here. We have Michael McConnell to my immediate right, who many of you should know, who's professor of constitutional law here. He's a former judge. We go way back, longer than he realizes, because when I was in law school, one of the articles, I thought it was when I was in law school, it turns out it was after, right, immediately after law school. One of the articles that I spent a long time with, trying to figure it out and probe the intricacies of it, was an article called Originalism and the Desegregation Decisions, which was actually written by Professor McConnell before you were Professor McConnell. No, you were Professor McConnell. You were Professor McConnell, and then you became Judge McConnell, then became Professor McConnell. So that was my first introduction to Michael McConnell. Kim Forde-Mazrui is another law professor from the University of Virginia. He's been the director of their the equivalent of the Racial Justice Center at the law school there. Kim is also someone I go way back with. I'm delighted to have him out here from Charlottesville. When I was first on the job market for looking for academic positions, Kim was one of the first people I connected with at UEA. He asked some great questions in my job talk, which I still remember, and I think they were great questions because I think I had good answers. So it was all good, and we've been friends ever since then. So I'm delighted to have him out here.
I went to Michigan for college and law school. National chance.
And you know I'm from Ohio. Why'd you say that? Okay. So today what we're going to do is to use the Supreme Court's decision in Students for Fair Admissions as a jumping off point to consider how history bears on a question that's central to constitutional law, which is a question of, does the Constitution mandate, this seems like it's going in and out, does the Constitution mandate governmental colorblindness? That's a question that featured centrally in the court's decision in Students for Fair Admissions, and it's also featured centrally in many other cases in the recent past. In Students for Fair Admission, just to give you a brief primer to put us on the same page, the question was the constitutionality of affirmative action policies that had been challenged at the University of North Carolina and also at Harvard University. There were a number of different opinions in the case. The majority opinion was written by Justice Roberts, which of course prohibited race-based affirmative action. But there were the concurring opinion by Justice Thomas. Then there was a dissenting opinion by Justice Sotomayor in which they took up the question of the implications of the history for the interpretation of the Equal Protection Clause. And they took diametrically opposed positions, as you might imagine, with Justice Thomas interpreting the history in one manner and Justice Sotomayor interpreting the history in another manner. So in this session, what we want to do is to probe these different interpretations of the history. Is one right and the other wrong? How can they have such different interpretations when they're relying on the same history? Or perhaps they're not relying on the same history. Perhaps they're relying on different sets of facts. These are the questions that our speakers will take up. As at many Racial Justice Center programs, our goal here, and my personal hope for the session, is that we can, for all of you, for many of you, undermine ignorance and also undermine certainty. Ignorance and certainty. Those are two of the sources of the bad place that we're in American society right now. They're sources of polarization and division. And so in trying to consider this question of history and the 14th Amendment, we're hoping to undermine both of those and perhaps bring us all together and create a basis for common conversation. So now I'm going to turn it over to the panelists. And the structure we have is that they'll each open with some remarks, and then I'll pose some questions to them, and then we'll open it up for questions from the audience. We want this to be interactive and to get all you guys' questions in. So if you hear issues that prompt something in you while they're speaking, make a little note of it, right? And then we'll get to that during the question and answer period, where we'll have people go to these two mics on the side for Q&A. Okay, so let's begin with Professor Michael McConnell.
Thanks a lot, Rick, and thanks to everyone for coming here tonight. Oh, my mic is not on. Let's see.
Little button on the top.
Is that better? Yes. So thank you, Rick, and thank you all for being here. We're going to be talking about the history of the 14th Amendment and what it has to say about colorblindness and related issues. I do want to say at the beginning that does not. I mean, we could be talking about any number of things. We could talk about, a social impact. We could talk about economics. We could talk about precedent. We've chosen to talk about history because that's one important issue. We don't ask anybody to necessarily adopt the view that the Constitution has to be interpreted in light of the history, but just that the history is something of interest and significance. And my plan is not to be in an advocacy mode, but just to talk through the basic texts that come up that are related to the 14th Amendment and the question of color blindness. And I didn't know that Rick was going to say he's combating certainty, but I suspect he's going to like what I have to say, because this is I think the story here is much more complicated than either Justice Thomas or Justice Sotomayor let on in their opinions, that they were both in sort of lawyer mode. I actually plan to be in, professorial mode and just to talk about the texts and present them to you, and you can judge for yourselves. And if I might just, cut to the chase, I think that there's going to be evidence here for both sides in the debate. I don't think it's necessarily evenly matched, but there's evidence going both ways. I think the predominant impression that you may get when you've seen the evidence is that those who favored and framed and adopted the 14th Amendment were predominantly interested in formal equality. That is, that they were they opposed formal racial classifications. They were not particularly interested. There's very little discussion of intent, discriminatory intent, or benign intent. There's very little discussion of actual social impact in these debates. And where might that lead us? For today, I'm not going to talk very much about current implications, but that may lead us to the conclusion that when governmental institutions actually legislate, along racial lines, that is not consistent with the basic tenor of the 14th Amendment, but that does not prevent governmental institutions from taking race into account and devising various social policies. And so, in particular, my colleague here, Professor Forde-Mazrui, has been writing about, including in the Stanford Online Journal coming up, and writing about how various educational institutions can respond to the Supreme Court's decision in ways that may comport with that decision. And I think we may see that they also comport with the original understanding, and that the history actually provides quite a lot of support for that way of thinking. But But I don't want to begin with the conclusion. I'd like to begin with the actual text and talk about it. So I usually don't do PowerPoints, and it's not going to be an outline of my talk. But because we're actually talking about text, we're talking about the words of the Constitution and the other fundamental documents having to do with the 14th Amendment, I thought it would be good that we have all of it in front of us. And so, if the question is basically, is this colorblind? Let's, look at the language. It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. I think the most striking thing about this is it doesn't mention race, right? And so no mention of race whatsoever, right? It talks about citizens, which includes both black and white. The immediate, the very first sentence of the 14th Amendment guarantees citizenship to all persons born in the United States, and most emphatically is a refutation and an overruling of the Dred Scott decision, which held that persons of African descent cannot be citizens. So black and white are citizens. So it refers to citizens. It talks about any person. That's neither black nor white nor male nor female. The idea that this amendment is limited to the particular context of discrimination against freed former slaves doesn't seem to be there. It's any person, any citizen, and any person, and then it says the equal protection of the laws. Whatever protection of the laws may be, we're talking about a principle of equality. So it doesn't even single out race. This is one of the things that Justice Sotomayor, actually it's something Justice Jackson pointed out, especially in the oral argument in the case, is the lack of racial language in the 14th Amendment. Well, where does that come from? The first important proposal for the 14th Amendment came from the American Anti-Slavery Society, Wendell Phillips being the driving force here. And this is a resolution that they passed on June 22nd, 1865, just at the end of the Civil War. Their proposed amendment was, no state shall make any distinction in civil rights and privileges among the naturalized citizens of the United States residing within its limits, or among persons born on its soil, or persons parents permanently resident there, on account of race, color, or descent. So now we do have language of race. This proposal is all about race. And the significant point here, I think, is that these are the radicals of their day. These are the people who are most interested in following up the Civil War with a fundamental transformation of the race relations of the United States. These are not the moderates. These are not the conservatives. It is the radicals who are the champions of explicit colorblindness back in 1865. No distinction on account of race, color, or descent. When it comes to the 39th Congress and the debates over the proposed 14th Amendment, on the same day, well, actually December 5th, December 6th, succeeding days, there were two proposals. Now, I'm leaving out, of course, the 14th Amendment in the end has 5 sections. That was Thaddeus Stevens's work, because he's the first one to have proposed the basic structure here. But Thaddeus Stevens and John Bingham, both in the House of Representatives, present diametrically different proposals for what they thought should be the 14th Amendment. And again, Thaddeus Stevens was the radical of the radicals. I mean, he was the most, well, there were a few others in his camp, but essentially he defines the radical end of the civil rights movement. And John Bingham was generally credited with being the principal author of the 14th Amendment. I'm not sure he really deserves that title, but he's often credited that way, is generally regarded as a moderate Republican. And remember, it's the Republican Party that is the champion of the 14th Amendment. The Democratic Party was almost to a man opposed to the 14th Amendment. So the radical proposal, very similar to the Anti-Slavery Society proposal, not surprisingly, all national and state laws shall be equally applicable to every citizen, and no discrimination shall be made on account of race or color. This is important, I think, because the framers of the 14th Amendment had before them a colorblindness proposal. I mean, this is unmistakably a colorblindness proposal. Had that proposal been adopted, much of our modern debates just wouldn't be taking place, because it would be the plain language of the 14th Amendment is colorblind. That was rejected. Right? That was rejected. And so we want to think about why. Why was it rejected? But I think a key thing that people who advocate for a colorblind interpretation of the 14th Amendment need to answer is, well, why are you advocating for something that was actually rejected? Right? Because the clear, unmistakable colorblind draft from no less than Thaddeus Stevens, it was rejected. So what did Bingham propose instead? The Congress shall have power to make all laws which shall be necessary and proper to secure to the citizens of each state all privileges and immunities of citizens in the several states, and to all persons in the several states equal protection and the rights of life, liberty, and property. Just like the 14th Amendment that we now have, no mention of race. So you have a race-oriented, colorblind proposal, and then you have this, dare I say, somewhat vague proposal. First of all, Bingham's proposal only empowers Congress. It is not a constitutional principle. It's a grant of power to Congress. Now, that is not the way the ultimate 14th Amendment is worded. So in that respect, Congress, the 39th Congress, abandoned Bingham's original vision and went to something in which the Constitution actually forbids laws which abridge privileges and immunities of citizens and so forth. But it's all talk about citizens and persons. Now, why might that be? I actually don't think that this was an argument about colorblindness. What I think this was an argument about what the scope of the amendment would be. That Thaddeus Stevens's colorblind amendment applied to all national and state laws. All national and state laws. What I think Bingham and the moderate Republicans wanted to do was to have these principles apply to some but not all. to apply to privileges and immunities of citizens, which are the most fundamental rights, but not to everything. And so what are they thinking of? Primarily, what they're worried about is voting. And the moderate Republicans were not ready at this point to extend the suffrage to the freedmen. They also weren't ready to extend the vote to women. So the vote was the most important point of contention, and privileges and immunities of citizens in the several states is a kind of code for common law rights, but not political rights. Now, in addition to voting, this would include such things as jury service as well. There was also some discussion of school segregation and also some discussion of miscegenation, but voting is the thing that was most on their mind. And what Bingham does is he proposes something which is limited to privileges and immunities of citizens, which they understood not to include political rights. By the way, how do we know that that's true? The 15th Amendment was necessary in order to extend the principle of racial non-discrimination to voting. There would have been no need for a 15th Amendment if Thaddeus Stevens' original proposal had been adopted and all laws were subjected to the no racial discrimination rule. So it was some, but not all. I think that's the main thing that's going on here. But it also has to do with Bingham's ideology, and he's not alone in this. But his ideology is based, he is primarily thinking in terms of the rights of citizens as opposed to anti-discrimination just sort of as in an abstract sense. What he wants to make sure is that the freedmen are guaranteed the fundamental rights that they need to be able to operate in society. And here it's useful just to remember the principal impetus for the 14th Amendment was that after the end of slavery and the 13th Amendment ended slavery, most of the states of the South enacted what were called black codes. And these laws were they're unbelievably awful laws, but they essentially what they did is they denied the former slaves the rights of property contract, right to sue, equal treatment of the criminal law. So most importantly, they did not have the right to enter into contracts freely. They had to, like you couldn't just not work. They were required under these laws to enter into contracts, and then they couldn't break them. So they were, what does this mean? That meant that they had to be working back on the plantation, and it was actually going to be a criminal violation for them to do anything else. And they were denied the right to own their own, the product of their own labors. They were subject to physical mistreatment, which is to say torts, different criminal laws. This was effectively what the Black Codes did, was to put the former slaves back into every material condition that looks an awful lot like slavery without the formal status of ownership, right? So it effectively recreates slavery. And the 14th Amendment was primarily designed to do away with that. But the first thing that was happened before the 14th Amendment, almost immediately before, and these things are debated almost simultaneously, Civil Rights Act of 1866 is directed against the Black Codes. All persons born in the United States are declared citizens, and such citizens of every race and color, note every race and color, without regard to previous condition of slavery or involuntary servitude, except as punishment for crime, shall have the same right. The same right, and here we have a list, to make and enforce contracts, to sue, be parties, give evidence, inherit, purchase, lease, sell, hold, and convey real and personal property, and to the equal benefit of all laws and proceedings for the security of persons and property, right, as is enjoyed by white citizens. What is this list? Think about the first year law school curriculum. This is contract rights, it's property rights, it's tort law rights, it's criminal law rights, and it's civil procedure rights, the right to sue and be sued. And it's really a very clever idea. Rather than having a national law that attempts to decide, well, what are contract rights? These are all state by state, they're state by state variations. Rather than having a national law, they basically say, well, whatever a state does for its most favored set of citizens, namely its white citizens, they have to extend to everyone without regard to race or color. And it's the same right? And so, is this colorblind? I think the spirit of this is heavily colorblind. It's all persons are entitled to equal rights. There's no suggestion that it's when you look at it, if you squint at it carefully, it does not actually, and imagine an affirmative action law. They didn't have anything of the sort at the time, but imagine one. Does it violate the Civil Rights Act of '66? Well, if there's a law that treats white people less favorably, that does not deny anyone with respect to race or color of the same right as enjoyed by white citizens, right? That is the right that's enjoyed by white citizens. The Civil Rights Act of '66, although I think it has a spirit, it's like a flavor of colorblindness, is not literally prohibitive of something like affirmative action. But when you see the Civil Rights of '66, it was vetoed by President Johnson for lack of constitutional authority. And the principal, not the only, but the principal purpose of the 14th Amendment was to provide constitutional authority for the Civil Rights Act of '66. As soon as the 14th Amendment is ratified, Congress repasses this. This was the two things are very closely entwined. And now it becomes easier to understand what John Bingham has in mind. Why is he phrasing the 14th Amendment the way he does? Is because those privileges and immunities of citizens, that's the right to contract, hold property, have protection of tort law, sue and be sued. Those are the fundamental privileges and immunities of citizens. And he's saying Congress does have the power to pass the Civil Rights Act of 1866. It has the power to make laws to secure to the citizens of every state all the privileges and immunities. So you can see that this is, although he doesn't mention race, the context here is all about defeating the black codes from the South. But the technique is one of guaranteeing to all citizens these fundamental privileges and immunities, but not everything, not the right to vote. Another important piece of legislation that is often cited and has bearing on our current debates is the Freedmen's Bureau Act. This is often regarded as race-conscious legislation. It certainly has the purpose and effect of having a federal government apparatus in the South that is designed to protect the former slaves, which arguably is a racial category, right? And so this is definitely race conscious, even if it doesn't use a formal racial classification. But look what it is. It says it extends to such loyal refugees and freedmen, these various benefits designed to enable them to enjoy the freedom of granted by the 13th Amendment. Loyal refugees and freedmen. Who are these loyal refugees? Well, the loyal refugees were white pro-union people in the South who were driven from their homes. And if you look at the legislative history of the Freedmen's Bureau Act, you'll see a number of occasions where Democrats, again, the opponents of civil rights, Democrats would say, oh, the problem with this bill is that it's class legislation designed just to help one race. And, there are different responses to that, but the most common response is to say, oh, no, this isn't just one race. Loyal refugees, this applies to some white people as well as to some black people. And so it doesn't, your criticism is not well-founded. Well, think about that for just a moment. It does suggest, right, a highly formalistic understanding of what race discrimination is. And so for them, as long as it was, there were some white people involved, it didn't violate the principle. I also think it's useful just as a mental exercise to ask ourselves the question, what kind of a term is freedmen? These are the recently emancipated, former enslaved people, right? All of them are black. This is like there were no white slaves. All of them are black. So it is an entirely racially defined category. But is it really a racial category? Because the experience of having been a slave put people in a very difficult situation. Here you are, you're a slave your entire life, and suddenly you're free. Are you like in a position to, behave in a free market economy, or are you literate? Do you know how to you're at a huge disadvantage, not necessarily because of your race, but because of having been a slave. And so maybe the category of freedmen itself should not be regarded as a racial category so much as it is an experiential category. But I think insofar as we want to ask the question, did the folks who created the 14th Amendment believe in legislation for the benefit of the black race? The answer is complicated, right? Because that certainly describes what the Freedmen's Bureau Act does, but it doesn't quite describe what the Freedmen's Bureau Act says. And this is why, among other reasons, I'm inclined to think that what they were most worried about is racial classifications as opposed, and they weren't, the fact that this was actually for the benefit, and very few loyal refugees, by the way, ever got any benefits under this act. So it's in terms of what actually happens, it's a racial category. And then I'm going to mention one other category of evidence, which is what do people say? And these are a few quotes plucked from the researches that I did in that article that Rick was kind enough to mention, which has to do with the Civil Rights Act of 1875, which was all about segregation. I can't guarantee to you that I'm not cherry picking, but I can tell you I don't think I am cherry picking. I was not writing this article about colorblindness. I was writing the article about what were the arguments that they were making, and I'll just quote, some things that important people said. So Free government demands the abolition of all distinctions based on color and race. William Tecumseh Sherman, the author of the Sherman Antitrust Act, among other things, says, as long as you have distinctions and discriminations between white and black and the enjoyment of legal rights and privileges, you will have discontent and parties divided between black and white. A black representative, by the way, there were quite a few. There was in the 1870s, there were a large number of black representatives in the House of Representatives. We've kind of forgotten about that. One of them, John Lynch, says, the duty of the lawmaker is to know no race, no color, no religion, no nationality, except to prevent distinctions on any of these grounds, so far as the law is concerned. Charles Sumner, who was like a hugely important advocate of non-discrimination, says that the law takes no notice of Negroes being different from other men. He says the law makes no discrimination on the basis of color. Another black representative, Richard Kane, says, my understanding of human rights is all rights to all men without regard to sections, complexions, or anything else. I know of no quotations that cut the other way. So it certainly was the aspiration, and I think primarily of the most radical reformers of the time, the aspiration was colorblindness. Thank you.
Sorry, I just bought a large digital clock because I'm sight impaired, and it's messing up on me.
You're fine.
All right. Okay. Well, thank you very much for being here, and thank you to Professor McConnell and Professor Banks for this important discussion. Although I've taught constitutional law for 28 years and spent a couple of classes on originalism, I'm not an originalist scholar, and I'm not a historian. So I come into this with a lot of uncertainty and a lot of ignorance. But I've been trying to understand it, both in support of my teaching, but also in support of engaging with the historical emphasis that we see at the Supreme Court in the last few years with abortion rights, with gun rights, and of course with affirmative action. So I come at this with sort of a curiosity to learn what does the history tell us if we take originalism seriously. So I've been getting up to speed on originalism and the history around the Reconstruction, and I just want to share with you what I found for the sake of discussion. So in researching it, I've read not only legal scholarship, but also historical scholarship, including renowned Reconstruction historians like Eric Foner and David Blight, as well as the excellent scholarship by Professor McConnell. And as a result of that, I've come to 4 propositions that are open to continued modification and refinement. But the first is that originalism indulges in a presumption of constitutionality. That is, when the historical evidence is not tolerably clear, then we should defer to the political process. Justice Scalia was one person who made this. I think a more eloquent explanation of this point comes from Professor McConnell. He writes, originalism defers to present-day enactments of political branches. And forgive me, I'm sight impaired, so despite the size of my font, I may lack eye contact with you at times. To defer to the political branches, according to most practitioners of this view, the decisions of the people's representatives enjoy a presumption of constitutionality and should be displaced only when they are demonstrably inconsistent with prior constitutional commitments manifested in text, history, and tradition. Thus, textualists and originalist judges do not focus primarily on text and history, but rather primarily on the right of the people to govern themselves through democratic institutions. If textual and historical sources are indeterminate, judges are not free to resolve the ambiguity in favor of their own preferences, but rather must defer to the decisions of the legislature. Professor McConnell in 2006. So that leads me to frame the question, not just whether affirmative action is consistent with the original meaning of the 14th Amendment, but rather is the historical record sufficiently clear to overcome a presumption of affirmative action's constitutionality. The next 3 points I want to make from my research are that first, at a very kind of general level, there isn't a sufficiently clear understanding with respect to the question at hand. There are easy cases that originalism can decide, including on racial issues. But on the question of whether race-based affirmative action has been forbidden by the 14th Amendment, I think the record is insufficient to overcome the presumption of constitutionality. Historians and legal scholars offer multiple and conflicting meanings. If you look to congressional debates, if you look to state ratifications, if you look to newspapers, if you look to people in the several states, if you look to, they had black constitutional conventions during Reconstruction, people were often advocating for different things, and constitutional amendments are often compromises among competing forces, often framed at levels of generality that are designed to be able to sell them to different regional constituents and say, don't worry, it won't do that, it can do this. See, the language doesn't preclude that. Some thought it would grant land, some thought absolute colorblindness, some thought it would be, that Andrew Cull says the rejection of the race distinction language meant that they wanted courts to have authority to decide what kinds of discriminations are reasonable with respect to privileges and immunities. Some say it matches the 1866 Act that Professor McConnell quoted, contracts and property and access to courts. Some say it matches the Bill of Rights. Some say it's a subset of the Bill of Rights. Some say it's the Bill of Rights plus more fundamental, some list of unspecified fundamental rights that could, in theory, even capture rights today that weren't considered fundamental then, but which are considered fundamental today. So there's a lot of unanswered questions with respect to, it also includes, is it absolute colorblindness? Is it what's reasonable? Does it have to satisfy compelling interests? Or is separate but equal consistent? Today that seems repugnant. But considering that they were going from slavery to abolition of slavery and then some measure of equality, the idea that black people would have access to privileges and advantages that white people had, but not necessarily on an integrated basis, was itself still revolutionary and not clearly prohibited by the very general language of the 14th Amendment. So I think there's a lot been left to court interpretation and perhaps congressional legislation to the extent that there are ambiguities that Section 5 may allow Congress within the scope of the amendment to resolve. But I don't think it justifies court saying that this has been clearly taken away from the democratic process. So that's kind of the general point. Then turning to the more specific point of looking to state practices and congressional statements and behaviors in the context of education, both lower and higher education. The history supports segregation. Think of in the abortion case, the court said 1868, abortion was illegal in most states. It continued to be in the immediate aftermath, so it's not guaranteed by the 14th Amendment. Same with gun rights, etc. Justice Thomas and Justice Sotomayor debate what the states and the Congress were doing in the most important period is 1866 to 68. I think Professor McConnell makes legitimate points that there can be some, though decreasing relevance once you move later than 1868. But if you look at practices at the time, with respect to education, much of this is in the opinions, but not all of it. In the congressional debates, they tended to focus, as McConnell suggested, on the Black Codes and the Privileges and Immunities Clause. It's also true that they weren't guaranteeing voting. That would have defeated the 14th Amendment, especially in the border states. But they also shared a distinction not just between political and civil rights being in the 1866 Act, but also social rights, meaning intermingling between the races. And that would include in public accommodations, that would include in marriage and sexual intercourse, and that would include, in the understanding of the day, in schools. And it was expected, indeed, school segregation or school integration was often a worse fear on the part of many white people than suffrage. So it was left out not because school was primitive. It was somewhat in the South, but it had been developed significantly in the North. And in the South, they knew they were having to develop schools. They were already in the process of developing schools through the Freedmen's Bureau. They knew education was going to be a key important task of Reconstruction, but there was no inclusion in the 1866 Act or in the 14th Amendment of equal access to schools, let alone integrated access to schools. DC schools continued to be segregated and were funded by Congress, and efforts by Sumner to integrate schools were defeated during Reconstruction. State practices, not just in the South, but also in the North, segregated schools in most states, aside from a small set of New England states and upper Northwest states. And these were often states where the population of Negroes at the time were, in this low single digits. So having a separate school system was often expensive and not something that they worried too much about because they really didn't have many black people to contend with. In higher education, which the scholarship on Brown and desegregation often doesn't focus as much on, in the southern states, virtually every former Confederate state just continued to exclude black people from the mainstream, flagship, and other white colleges. There was a brief period where there was some attempt at integration in South Carolina, but that was short-lived. But most states prohibited in the North. A lot of schools prohibited blacks. Some admitted a few. They tend to be few and far between. And in fact, the black colleges were created, what we know as HBCUs today were created, many of them during Reconstruction with help from the Freedmen's Bureau, run by the federal government, private philanthropy, and then to some extent by the states, who saw the creation of black colleges as both necessary and sufficient to avoid integrating white colleges. We have to give them higher education, and if we don't want them going to our schools, we can do so with sufficient cause by creating separate black schools. Senator Morrill, who advocated for land-grant colleges, a big advocate of education, 1862 Act provided land grants to many colleges. In the late 1860s, early 1870s, they were discussing extending that to Confederate states that were readmitted. But one of the questions that came up was, what if they take the money and only use it for white students? Everyone said, well, that's a real possibility. So we have to try and control the money in some respect. Senator Morton from Indiana, who wasn't a fan of the law, interjected what many understood in the debates as a poison pill. This will defeat this law if we can amend it to say the money has to go to the creation of mixed colleges where the students are integrated. and he succeeded. It was defeated. So Senator Joseph West from Texas suggested a modified amendment that said, well, okay, how about the money has to be allocated so as to go to black students in white schools proportionately, but they can go to different schools. That actually gained a few more votes, still not enough. But interestingly, no constitutional objections were made to the land grant funding being used to create segregated schools. And also, interestingly, it was explicitly acknowledged by Morrill and others that if there were a condition on either integrating schools or apportioning it equally to segregated schools, this would only apply to newly funded colleges, not colleges that were previously created by federal land grant funds, which is a bit odd if you think it's unconstitutional. We're going to let people continue to use funds and land that we've given to create colleges with, but since we did already, they can continue to violate the Constitution. So that's lower and higher education. Moving away from segregation, or education and looking to other things, and let me emphasize, I'm talking about during Reconstruction, including the early period of Reconstruction, roughly 1865 to 1870. By 1877, white self-determination had been largely reasserted. Because there's somewhat of a narrative, and there's some truth to it, that there was kind of a heyday of multiracial democracy during Reconstruction in the late 1860s, maybe into the early 1870s, where the Reconstruction governments, congressional enforcement acts, Union troops helping to enforce it. But then when the North pulled out and the white Southern Democrats reasserted total dominance in the South, then Reconstruction was brought to an end and segregation was begun. So segregation is like late 1870s to the 1950s. Well, the point I'm making is there was segregation throughout the heyday of the multiracial democracy. So even Reconstruction legislatures that had substantial numbers of black legislators were creating schools for black children, not demanding that they be integrated, and same with higher education. So also during early Reconstruction, going beyond education, state practice, I mentioned schools, I mentioned anti-miscegenation and anti-interracial fornication. I believe, but Rick would probably know better about me, that interracial adoption was also, to the extent I've been able to research it, it seems that interracial adoption wasn't allowed till well into the 20th century, but I don't have documentation of some isolated practices in early Reconstruction. The militia, which is interesting, states in North and South created black militia following the Civil War and into Reconstruction. And this wasn't just a continuation of segregation that by inertia was left in place, because blacks weren't allowed to serve in the militia before the end of the Civil War. So Virginia, North Carolina, Maryland, Massachusetts, Pennsylvania, Connecticut, Ohio, Tennessee, Michigan created state-level militia for black soldiers who wanted to serve in them. That was often seen as a way of getting respect, getting rights, proving yourself a decent job. So this wasn't conscripting them, this was allowing them to serve in black militia. And they were segregated throughout early Reconstruction hospitals in the South. Freedmen's Bureau helped to build black hospitals for black patients. In the North, there were often black wards within larger white institutions. Again, throughout Reconstruction, not just the end of Reconstruction. Mental asylums, orphanages. I think it was South Carolina had an segregated institution for the blind during Reconstruction. Penitentiaries often had black and white cell blocks. Often whites were incarcerated in cells. Blacks were put to chain gangs. One thing I learned interestingly is that prisoners before the end of the Civil War were largely white. Blacks were, treated, at least during slavery, as punished by their masters. You don't want to put them in a jail where they can't work, unless it's sort of temporary as a punishment. but with the consent of the master. So they were punished on the plantations where white people were sent to prison. But following the Civil War, blacks became the dominant race in prisons. And then finally, and sadly, cemeteries were segregated. Federal practice, right? This is the federal government who passed the 1866 Act, passed the 14th Amendment, mentioned DC schools. Sotomayor mentions the aid to destitute colored women, not just freed women in the District of Columbia. The Freedmen's Bureau helped to create, again, schools and hospitals for black people, not just for freedmen. Interestingly, the Second Freedmen's Bureau Act of 1866 actually approved the sale of land in the coastal South Carolina to the heads of families of the African race, explicitly the African race, not freedmen. The military, again, blacks didn't serve in the federal military. Well, they did in some early wars, but generally by the beginning of the Civil War. But they were eventually allowed, and 200,000 fought for the Union side. They created black regiments that continued to be segregated until Truman's 1948 order, which itself took a few years to implement. You may have heard of the black Buffalo Soldiers in the West. So the federal government also segregated military service citizenship. In 1790, the U.S. Naturalization Act limited citizenship to free white people, which goes to show, how white supremacy defined the nature of citizenship. Following the Civil War and during Reconstruction, the Naturalization Act of 1870, right, just a couple years after the 14th Amendment, same year as the 15th Amendment, the Republicans amended it to say to become a citizen, not only do you have to be white, you can also be a person of African nativity or African descent. So they added blacks, but they knew about Indians, they knew about Chinese, they knew about other Asians. So they acted race consciously to include black people, but not other races in the Naturalization Act. And then my final example from that period is Arlington Cemetery. It was taken over by the federal government in 1864, June 15th, partly from Robert E. Lee's land. Up until that point, there were black, white, including both Confederate and Union soldiers being buried there without being integrated. The federal government segregated, created Section 27, Section 23 for U.S. CTs, United States Colored Troops, and until the middle of the 20th century, new burials in Arlington Cemetery were segregated by race by the federal government. And then those are all my historical examples. My final point is just a puzzle, and I don't know if Professor McConnell wants to respond to this. Justice Scalia and Thomas have been touting originalism for decades, yet until Justice Thomas's attempt in this case last summer, he and Scalia never made any really even attempt at an originalist argument in any of the affirmative action cases. I think Scalia had at least 6 prior to the summer, not even including voting cases, which was another opportunity they could have made an originalist argument. Thomas had at least 5 cases prior to this year, not including the voting cases. Maybe I'll cut him some slack in Adirondack, which came out a month after Professor McConnell's article, but he has sharp clerks, so they should have found it. But okay, cut him some slack in 1995, but in Parents Involved, 2007, Gruder and Gratz, 2003, both Fishers, 2013 and 16, whatever they were, no attempt at originalist arguments. So, there's just a puzzle. Why not, if the evidence dispassionately really weighs in favor of an originalist justification for invalidating affirmative action, why have they taken so long to mount that argument? And we can maybe talk more about it. I think the argument he makes is fairly weak. But in conclusion, just to the extent originalism looks at practices and promises made at the time of ratification and in the immediate aftermath, then both federal and state practices strongly support that segregation in a variety of contexts, including but not limited to lower and higher education, was considered consistent with the 14th Amendment. And at the very least, the question is sufficiently debatable that democratic legitimacy, honoring the will of constitutional commitments, but also honoring present democratic processes when those constitutional commitments are not clear, they justify deferring to current present-day legislatures. Judicial restraint justifies the same thing. So with that, I thank you for your attention, and I look forward to this discussion.
I think we should move to the audience. We don't have much more time, do we?
These are such rich presentations. So if people have questions, I'll offer one or two questions. But if people have questions, go to one of these two mics, and then we'll get to you in just a minute.
How much time do we have?
We have another 30 minutes. Okay. Let me start with one question. These are one of the issues that came up in the oral argument for the Students for Fair Admissions case was whether it would count as a racial classification based in light of this history if a school were to award preferences to descendants of enslaved people in the United States. How does the history bear on that question? That's for either of you.
It's a good question. I was actually surprised that the one of the lawyers for the schools thought that it would be a racial classification, given that at least in the scholarship, the distinction between freedmen and black people has been emphasized by opponents of affirmative action. So, if the classification of having been a slave is not a racial classification, then why wouldn't the classification of being descended from a slave also not be a racial classification? So my initial, so long as the kind of reason for it isn't a subterfuge for just choosing something that would correlate to race. So my initial reaction is it shouldn't be a racial classification, and it would be kind of tragic if the closer you get to the actual people who have descended from the greatest victims of slavery are somehow the least entitled to be helped by our society would be ironic. The one case that I haven't read for a long time, but gives me pause as a doctrinal matter, is Rice versus Cayetano, in which the Supreme Court said that reserving voting privileges for certain Hawaiian lands to Native Hawaiians was a racial classification. And I believe the definition was you're descended from people who lived here prior to a certain date. And I think it was a date when white people came. But I think the point was made that, not all people of Hawaiian stock lived here that far back, and there could have been some people who don't appear Hawaiian or Polynesian who were here and there. So it's simply dating back to a location. And they said that because it traces ancestry, that itself makes it a racial classification. So that might suggest that being descended from enslaved is a kind of racial category.
I mean, I think I agree with all of that. I haven't really given that much thought to Rice versus Cayetano and how the categories were defined. I do think that to administer a statute having to do with descendants of slaves would be a nightmare.
Okay, on that note. Sir.
Yeah, thank you. I'd like to ask a question about the language proposed by Wendell Phillips. And it seemed that would have limited the protection to just naturalized citizens, that nobody else could have brought an argument under the language that we discussed as being by Wendell Phillips. That's one question. Then I'd like to take a look at this issue in terms of nation building. we made an attempt to change the character of the nation through Reconstruction. Some people would say it didn't work. Well, we didn't see nation building go so well in Vietnam either, for somewhat similar reasons. It wasn't culturally a norm in Vietnam to participate in the kind of government that we said we were advocating for them. Nation building hasn't quite worked. It seems culture becomes the upper limit to the potential of what the people are willing to do for themselves. And if we look at the United States today, it seems like one of the common threads we have today is a lack of participation in the political process. And with that, I'll leave my comments to that. Thank you.
I think if you look at the full language of the Wendell Phillips provision, you'll see that it also applies to persons born in the United States as well. So it's not limited to naturalized citizens. Your point about nation building is interesting. I think one way to think about Reconstruction was that it was a rather brief and abortive attempt at nation rebuilding. That is, the Southern society was so shaped by slavery that it was actually a different culture in many ways to the rest of the country. And I think some of the more radical architects of Reconstruction would have liked it to go on a lot longer and not actually lead to the readmission of the southern states until there had been a period of time sufficient to sort of do some nation building or Americanization or Northernization than that. But that was not have been popular in the North, let alone the South.
Okay. Let me interpose a question, and then we'll go to the question over here. Professor McConnell, this one is for you. Drawing on Professor Forde-Mazrui's discussion of the significance and the extensiveness of segregation in the context of education, would it be the right conclusion to draw that the prevalence of segregated education, race-conscious education at the during the 19th century, that sort of categorically refutes any idea of colorblindness in the context of education now?
Well, I don't think so. The segregated institutions, railroads, steamboats, and schools, segregation was the leading topic for the 1875 Civil Rights Act. It was debated for 4 years, extensive. I mean, it's voluminous, and it simply isn't true that racial segregation was accepted. Now, again, there's a distinction between formal classifications. So a distinction was drawn between so-called mixed schools, which would be actually integrated schools, and that commanded some support, but very little support, even among the Republicans in Congress. But the idea of racial classifications for segregation was debated, and in a series of votes between 1872 and 1875, large majorities of both the House of Representatives and the Senate, large majorities but always short of 2/3, voted for enforcement legislation of the 14th Amendment that would have forbade racial segregation. And they explicitly voted down separate but equal proposals on at least 4 occasions. So the advocates of civil rights were adamantly opposed to formal segregation of public education. Did this included even cemeteries? And it it actually passed with respect to transportation, and then that was what was held unconstitutional by the Supreme Court in the civil rights cases.
But cemeteries and education didn't make the final.
No, they did not. Cemeteries were too close to religion, and it was argued that that it violated the First Amendment to interfere with racial practices of churches. And this was not something, as I understand it, not something that the black representatives opposed, because having their own churches was one of the great, highly desirable after the Civil War. They were used to being forced to attend white-dominated churches, and to be able to have your own church with your own black pastor was highly treasured. Cemeteries were almost always associated with churches.
Do you mind if I ask you a follow-up? Professor McConnell?
Please.
Okay. So I agree with you that post-1868 history is relevant. I mean, you'll see some originalists say, you only look to 1866 when the 14th Amendment is being drafted, or at least through 1868 when it's ratified by the states. But I don't know how much the Supreme Court or originalist scholarship make the distinction I'm about to make, but I think there's a distinction between amendments that are viewed as kind of constitutionalizing pre-existing commitments or rights, like the Bill of Rights was, putting in commitments that limited the federal government in ways that the states often already did. So these were kind of long-standing traditional rights. And so it makes sense to kind of look to what did the states do at the time to get a sense of what do these phrases mean in terms of assistance of counsel and juries and things like that. But I think with equality and the Civil War amendments in particular, because they are dramatically changing the way society is going to do things, and in some ways, pressuring to arguably coercing the former Confederate states to come along, one shouldn't expect to see kind of widespread compliance during that period, because they're being forced to do something they don't want to do. It's not constitutionalizing something against the federal government that the states already want to do. So I do think that the original meaning of the 14th Amendment can have a meaning that isn't honored, at least widely, by the southern states. So I acknowledge that. That said, I'm struggling with, how far out from 1866 to 68, because you look at 1872, 1874, the Act of 1875, and I don't recall. I mean, I've read your article, but it's very detailed.
It was 30 years ago.
So I don't know how much of the exact personnel had carried over, but even if a substantial number of the same personnel had carried over, I mean, views can change. I think you might have used in your article the example of you could poll liberals in 1964 with the Civil Rights Act, and they would think it was mandated colorblindness. And then the same liberals 10 years later or less are advocating for affirmative action because views change when perhaps they see new problems. And during Reconstruction, in 1861, I think most Republicans weren't looking for emancipation. But by 1865, they were. in the 13th Amendment. In 1866, they weren't supporting suffrage for black people, but by 1869, they were. And even in the case of the 1875 Act, I mean, there's some, was it just that they were preoccupied during 1866 to not talk about education? Because one read of the during Reconstruction was that they either avoided or minimized or even, sold that this won't deal with schools. And so then if they come around later and say, well, actually it does, and you have to integrate them, there's a sense in which either their views have changed or at least what they sold to the ratifiers, including in the northern states, was in some ways obscuring the school question. So I guess my question is, how much relevance can you take from the votes in these later congressional sessions?
There's no magic answer to this. I'm impressed by the fact that after the 14th Amendment, there's a whole series of enforcement acts, and they go through and deal with one problem. And the 75 Act was the last of these, and then usually, how long after, I think it kind of tapers off, and how long, it's all kind of shades of gray. But with respect to Reconstruction, there really is an endpoint, because the Compromise of 1877 is a real thing. And this was, for those who are not familiar with this, I didn't study this in high school, and I hope it's now being taught in high school, because I think it's a really interesting, shocking, important event in American history. But the election of 1875 between Samuel Tilden, the Democrat, and Rutherford B. Hayes, the Republican, was a complete, no one knows who won. Even today, nobody knows who won. There were disputes over 3 or 4 important states, and it was debated in Congress over, how to count the electoral votes. If you think January 6th was a mess, well, 1876. And in the end, there was a compromise, and what the compromise was this, and the terms were really pretty clear. It's literally stated on the floor of Congress. The Democrats agreed to let Rutherford B. Hayes be president, in return for which Reconstruction came to an end. They withdrew the troops from the South, and they basically, the fig leaf here was, you can trust, the Southern governments to protect the rights of the freedmen, and and that didn't last very long. And so, I think anything after 76 is like a repudiation. But I'm inclined to think that when Congress is passing enforcement legislation for the 14th Amendment, that counts as what they thought the amendment meant. So I don't have any hesitation to say that counts as evidence. Now, if there's powerful evidence the other way, okay. But
thank you.
Please.
Yeah, so is this on? Can you hear me? So first, thanks for this great event. I've already learned a lot. I wanted to ask about, what tea leaves can you read in SFFA about the status and continuing vitality of strict scrutiny? I don't think that's come up much today, but I think there are a few odd features about how strict scrutiny is treated in SFFA. For one thing, I think the majority says something like the interest is too amorphous to even apply the strict scrutiny framework, and then that's picked up in the dissent. And then I wanted to ask, as a subsidiary question, what is the role of this historical analysis in applying the strict scrutiny framework, if any? My understanding would be the historical analysis would be salient to the threshold question of does the law potentially present an exception to the Equal Protection Clause? And then once there is an exception, the strict scrutiny framework would answer the question of, can we permit this exception to go forward? I don't know if that's quite the right way to think about it, but does history have another role to play in strict scrutiny? Or if you think the court is sort of moving on from strict scrutiny, then what is the adjudicatory framework that this history indicates? Is it just a categorical question of, well, the 14th Amendment would not have allowed this based on a historical understanding, and therefore that answers the question in total? Or is there something else to say about that? So thank you.
Wonderful question.
I guess I'll start. This has nothing to do with what we've been talking about. This is, reading this somewhat opaque decision. The decision is not based upon history. You ask, well, what does the history bear upon strict scrutiny? Nobody ever heard of strict scrutiny. Strict scrutiny is first mentioned in the late 1940s. It's a concoction of the modern court. It is not a historical thing, and so I don't know. And I think the opinion is extremely under-theorized. I don't really know what they thought they were doing, and the method that, if you look at Chief Justice Roberts' opinion, it's not based upon history. It's not really based upon a theory. It's really based upon throwing together miscellaneous quotations from more or less apt or inapt prior decisions and coming to the result. Here's what I think is the most fundamental uncertainty about the opinion. Besides the fact, putting aside for a moment, why they didn't go off on Title VI, which is, which I think would have been, this was what Gorsuch said they should do, and I just don't understand why that isn't right. But for purposes of anti-black discrimination, the court is quite clear that not only are formal racial classifications forbidden, call it strict scrutiny, but basically forbidden, but so also are ostensibly non-racial classifications that were enacted for the purpose of achieving anti-black discrimination. They are treated also as forbidden, strict scrutiny, if that's the way you want to talk about it, but absolute. No exceptions. I don't think there's ever been a case that doesn't go, in modern times, that doesn't go that way. The court in this case, for the most part, acts as if anti-white discrimination, affirmative action, is the same phenomenon. You would not know from reading the opinion that you would not think that they're different. It's like equal protection of the law, all persons, right? Same, except that for the last 30 years, opponents of affirmative action have said something like this. They've said, you don't need to have these crude, like race lines. We can achieve much of what we want in terms of social justice through plans like the Texas Top 10% plan, like the things that Thomas Jefferson High School was doing in Virginia. They're all like the things that the University of California systems have been doing since the adoption of Prop, 208. There are all kinds of things that are done in order to ameliorate the racial situation without, a formal racial classification. And that has been what opponents of affirmative action have been advocating for these many years. But if the two kinds of discrimination are identical, then those things are just obviously they're race-neutral means, but with the intention of having the racial effect. And if the two types of discrimination are identical, then they are unconstitutional. I just do not believe that John Roberts, whom I know very well, he and I clerked almost together, and have been friends ever since. I do not believe that John Roberts or the other members, maybe a few, maybe there might be 2 or 3. I don't believe that Amy Coney Barrett believes this. I don't think Brett Kavanaugh believes this, that those things are all unconstitutional. There may be some that are better than others. You know, there may be lines to be drawn, but the idea that any classification with the intent of creating a more integrated society is just unconstitutional. I don't believe that that's where they want to go, but there is nothing in the opinion that elucidates this because they don't have a theory. There's no theory in the opinion. So who knows?
Yeah, the question asked about history too, and it's true the majority opinion just almost acts like it's just applying existing precedent, even though it's applying strict scrutiny in a way that's really more like the court did in Croson, which is basically strict in theory, fatal in fact. There is Stanford Law Review is publishing a really good article by Sonia Starr at the University of Chicago that has Magnet School Wars in the title, if you're interested in kind of the cutting edge doctrinal
And an even better response by somebody, what was his name? Forde-Mazrui, I think his name is, who wrote the response. Recommend that.
Well, thank you. If we take history, if we really were to, if the court were really to impose Reconstruction era thought, I mean, there is a lot of uncertainty about what that thought means, as I said in my remarks. But one, I think, common view among scholars is that the Privileges and Immunities Clause is really where the action is, and it was kind of read too narrowly in the slaughterhouse cases. Justice Thomas, although he talks about the Privileges and Immunities Clause in other cases, like abortion and gun rights, he didn't in this case. He just talked about colorblindness being embodied in equal protection. But I think a serious originalist might say, well, if we were to return to the meaning there, then you might have either strict scrutiny or something even stronger, like colorblindness, or some reasonable, I mean, it's not clear what the test would be, but some sort of presumption of unconstitutionality, but only in cases where privileges and immunities are implicated. And I don't know, so that would include, you know, probably the Bill of Rights and the things in the 1866 Act. Arguably education, as Professor McConnell argued in his article, that even if it wasn't so in 1868, education may have become a privilege and immunity by the 20th century and by Brown versus Ford. But there's a lot of areas of law that currently would subject strict scrutiny if they were race-based, but wouldn't under original meaning of the Constitution. I mean, things like arguably, I don't know, marriage, certainly interracial sex is probably not a privilege and immunity. Segregation in kind of public accommodations, even if the law mandated it, might not be, you know, golf courses and theaters, maybe you could return to segregation if you wanted to. I mean, there's some category of rights that an originalist might say are not a privilege and immunity and therefore are not covered by even a colorblindness reading of the 14th Amendment because it's limited to those rights. The majority and Justice Thomas didn't go there. They treated it as all racial classifications by government are subject to strict scrutiny. But a more purist historical approach I don't think the court would go there, but might distinguish between privileges, immunities, and other types of rights.
We'll take
May I just
two more
add,
questions.
I agree with all of that and don't know the answer to it, but just one other point. Again, when they rejected Thaddeus Stevens' colorblindness, clear and amendment and adopted Bingham's privileges and immunities version that doesn't really, which is considerably less clear. One possibility is that colorblindness is true of both, but there is another, which you alluded to correctly. You attributed it to Andrew Cull, which is, he's not the only one, but there is support for the view that what Bingham had in mind was reasonableness. That is, even anti-black discrimination might have been okay, if reasonable for some reason. He probably wouldn't find that to be true in many cases, but in the discussion of women, this is very prominent. And so reasonableness might be an alternative test, but note that doesn't, it puts you to, if that's the path, it puts you to a choice between, well, we really have to give up, this strict scrutiny for anti-black discrimination as well, because this isn't an argument about affirmative action. It's an argument of discrimination. That discrimination is permissible if, reasonably related to some sort of legitimate public purpose.
Okay, sir.
And there's a gentleman behind me too.
Okay.
So first of all, thank you very much for the session. It's been great. My question is a tangential question. The discussion has really revolved around the newly freed black slaves, as it should. But there were also about 300,000 Mexican Indians in Texas and California, which were states at the time, that were enslaved. What, if anything, was done for those people?
Great question. That's going to be hard to answer briefly, as we must.
So I don't recall any specific discussion of Mexican descendants, but there was discussion of they would throw out as hypotheticals other ethnic groups. And, there's not much on this, but whatever there is, there was, they viewed that as an invidious discrimination too, except with the following caveat, that there were Westerners, I think particularly of Senator Stewart from Nevada, who were in a panic about Chinese immigration to the West Coast and were not at all interested in having them being covered. But the Mexicans, I don't remember any discussion of that.
Okay, so let's get both. We have one question over here, and then we have one over here. So let's get both questions, and you can respond to both. So we're going to bounce here and then there.
Can you guys hear me? Good. So given the state of where things are today, what do you think the founding fathers would think in terms of the Constitution and where we are now with civil rights?
Sorry, can you repeat that, please?
Given the state of things today, as they relate to like affirmative action, DEI, each of your opinions on what do you think the founding fathers would think?
Okay, so you can ponder that, and we'll go to the other side.
This may be beyond the scope of tonight's question, but it has been said that America has a race problem. If you agree with that, I wonder what your view of the nature of that problem is, and also how would that inform you about solutions to get at that problem?
Well, this is.
That's the last.
Yeah, these are. I mean,
How
these
about
are
I take
these
that
are
one?
broad
I'll
enough
take this
questions
one.
that we could have a whole nother session.
So
but-
I have no hesitation in saying they would be gobsmacked at this discussion, but I also think they would be, the more reform-minded of them would actually be encouraged that we're even having this conversation, because from the point of view of 1868, the idea that democratic